Welcome back. How's that for a pivot, huh? Thank you. Big thanks to Nosy Rosie, who sent me some new motions that were filed. They're filed on the 9th, it looks like. Is nobody talking about them? All right. Well, here we go. They were filed on the 9th of August, and we're going to take a look at them together. These are new filings filed by the defense on the Ashley Benefield trial. So let's take a look. The first is a motion to interview jurors or jurors, if you're in South Carolina. This is filed by the defense team of Ashley Benefield. And we're going to read it and we're going to talk about it. It's a motion to interview jurors. And here we go. Ashley Benefield, by and through the undersigned counsel and pursuant to Rule 3.575 of the Florida Rules of Criminal Procedure, in conjunction with and as part of her motion for a new trial, hereby moves the court to conduct interviews of the jurors in the instant matter. As grounds in support of the requested relief, Ms. Benefield submits as follows. Number 1, on July 30th, the jury rendered its verdict. Number 2, evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. This alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair trial and impartial jury and subjects the verdict to legal challenge. 3, during jury deliberations, a YouTube user, quote, that hoodie guy, end quote, I don't know who that is, posted comments on the Law and Crime Network's YouTube live streams of the, quote, verdict watch. These comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. I don't know who that hoodie guy is. Don't go look now, but go look later. And then they actually put a little link to that hoodie guy's YouTube channel in their motion. 4, the comments posted on July 30th of 2024 reveal A, that at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, that hoodie guy posted a comment stating, verdict incoming, Exhibit A1. I don't know if the exhibits are attached to these papers. Let's see. If they are, we'll look at Exhibit A1. No, they are not, unfortunately. B, at 10:25 p.m., that hoodie guy posted a comment stating, quote, per sources 5-1 guilty with the man stuck on not guilty or manslaughter. Exhibit A2. I guess the exhibits are just going to be screenshots of these comments allegedly made by that hoodie guy in the Law and Crime chat. I know you guys were watching it with me, so you probably weren't watching it on Law and Crime, but that's a little bit scary. And also, remember, it was 10:25 p.m. It was late that we got a verdict. C, at 10:27 p.m., that hoodie guy posted a comment stating, quote, my sister snuck a flip phone in, end quote, Exhibit A3. D, at 10:28 p.m., that hoodie guy posted a comment stating, I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. Oh, Laura says, I don't think this is that great. The YouTuber has like 0 videos and 13 subscribers. Yeah, it doesn't matter though, because now he's saying that his sister is a juror and he's getting his information from inside the jury room. His sister snuck a phone in there. So it's not, the issue is not that he's a YouTuber, but that he is a user on YouTube who had a sister on the jury. Right? E, at 10:28 p.m., that hoodie guy posted a comment stating, "My sister snuck a flip phone in. She texts me 5-1 guilty. May compromise on manslaughter." 5, at 10:30 p.m., a mere 2 minutes after that hoodie guy posted that the jury may compromise on manslaughter, the jury returned a compromised verdict of manslaughter. 6, the timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that that hoodie guy's information originated from within the jury room during active deliberations. This represents a breach of the jury's sworn duty and impacts the fairness of these proceedings, subjecting the verdict to legal challenge. 7, this alleged misconduct raises serious concerns about the integrity of the jury deliberations and the reliability of the verdict. Specifically, it raises questions about A, a juror smuggling an electronic device into deliberations, which is not permitted in the jury room. B, real-time communication of confidential jury deliberations with non-jury members. C, influences external to the evidence presented during the trial may have influenced the verdict. D, access to unauthorized materials affecting the verdict. E, the overall integrity of the fact-finding process being compromised. 8, the prompt removal of these comments from the Verdict Watch on the Law and Crime Network's YouTube channel live stream further underscores the seriousness of this potential juror misconduct. 9, in addition to the above, evidence has come to light indicating that the verdict may be subject to legal challenge due to juror 15, Sarah Yvonne Walcott, being untruthful during voir dire by falsely representing that she had not been a victim of a crime. Her son had been charged with a crime, and she had involvement in child custody / domestic violence / abuse matters. Well, I don't like that the juror was doxxed, but it wasn't redacted in the court file, so this is what we have. All right, so that's an issue. It's an issue. If you lie on a jury questionnaire, especially about things like this that could show bias, that's a problem. 10, juror 15 completed a jury questionnaire under the penalties of perjury, which asked, "Have you or a member of your immediate family been a victim of a crime?" Juror 15 responded untruthfully to the question by omitting that she, 1, had been a victim of a crime, battery, touch or strike, domestic related. Footnote number 2, let me just see what that says. Probable cause affidavit is attached here too as Exhibit B. I guess that was the probable cause affidavit for this juror's domestic in which she was a victim. On February 20th of 2016, when her live-in boyfriend, and they name him, intentionally slapped her in the face with an open hand 5 times, and that her son, they dox also, had been charged with felony battery against his pregnant girlfriend on August 31st, 2014, for which juror number 15 was the bond depositor. And then they put here the probable cause affidavit they attached and cash appearance bond attached as Exhibit C. Huh. Number 11. On March 18th of 2016, juror 15 filed a petition for injunction for protection against domestic violence against Mr. B in the 12th Judicial Circuit Court in Manatee County, Florida, and there's the case number. The allegations of the latest act of violence or threat of violence provided that Mr. Ballinger grabbed juror 15 by her hair and repeatedly hit her in the face, causing a black eye, damage to the inside of her mouth, and a swollen face. Then they attach a copy of the petition. 12, juror 15 was a respondent in a petition for injunction for protection against DV, filed on September 2nd of 2003 by her ex-husband, Charles, seeking protection for himself and their minor child, HJW, in the 12th Judicial Circuit Court in and for Manatee County, Florida, with the case number. Copy of Mr. Walcott's petition is attached here too, and provides in part juror 15 being threatening and violent, including cussing, slamming doors, threatening, and throwing his things at him. So it looks like she was the perpetrator of the DV against him. B, requested that his son come and stay with him until Juror 15 can get some help. Juror 15 attempted suicide and was hospitalized on or about July 18th, 2003. She called and told Mr. Walcott that she was going to take her own life. C, constant harassment and threats to his wife and himself. D, fear that Juror 15 might try to take his son's life along with hers the next time she tries to take her own life. E, request to keep his son until Juror 15 is well. Specifically, he requested supervised visitation until Juror 15 showed that she was stable mentally and financially. Right, Gamer Ducko. 13. Juror 15 was also a respondent in another petition for injunction for protection against DV filed on April 23rd, 2004 by her ex-husband, Charles, seeking protection on behalf of their minor child in the 12th Judicial Circuit in and from Manatee County, Florida. There's the case number. Copy of Mr. Walcott's second petition is attached here too as Exhibit F and provides in part, A, Juror 15 picked up his son by the arms and slammed him against the wall. All right, trigger warning, please. The minor child, while visiting with Ms. Walcott, expressed that he was afraid to go home. C, a report of CA filed with the Bradenton Police Department. D, Juror 15's boyfriend threatened to hunt Mr. W down and take his life. E, ongoing investigation by CPS. F, Mr. Walcott was seeking custody. G, the minor child was showing signs of being violent. Number 14. Juror 15's failure to reveal this information during voir dire amounts to juror misconduct and subjects the verdicts to legal challenge, entitling Ms. Benefield to a new trial. No, Juror 15 was a female. Somebody's saying Juror 15 was male. No, she's a female, right? They were talking about her as a she. And they named her. This motion is filed within the 10-day period prescribed by Rule 3.575 to address this urgent matter. 16, given the nature of the alleged misconduct, Ms. Benefield asserts that there is reason to believe that the verdict is subject to legal challenge on multiple grounds, including, but not limited to, A, juror misconduct, B, introduction of extraneous prejudicial information, C, influences external to the evidence presented during the trial may have influenced the verdict, D, violation of jury sequestration, E, violation of the defendant's 6th and 14th Amendment rights, F, jurors potentially receiving evidence outside of court proceedings to the detriment of the defendant's substantial rights. 17, this is bad. This has to be looked at ASAP, right? Kiki Kazoo, right, Mike? 17, the integrity of the judicial process and Ms. Benefield's constitutional rights are at stake. The court has both the authority and the responsibility to investigate this matter fully, including granting permission to interview all jurors who served on this case, to wit, and then they name them. There's only 6 in a criminal case in Florida, and that's because it was not a capital murder case. There was no death penalty on the table, and therefore, Florida rules allow for a 6-person jury. And I've said multiple times, I don't think that's enough. Wherefore, Ms. Benefield respectfully requests this court, A, grant permission to interview all jurors who served on this case, specifically, and then names them 1, 2, 3, 4, 5, 6. B, expeditiously set a time and place for the interview to be conducted in the presence of the court and the parties. C, summons the jurors to appear at the time and place set for the interviews. D, grant any other relief this court deems just and proper under the circumstances. Respectfully requested, XOXO. Neil Taylor, this is a big problem. This is a big problem. Darbykins says, possible she said she was a victim and didn't believe a word of it and swayed the jury. And you know what? We've seen that in so many comments. I know that you guys watched comments in other places and other chats, and so many people were saying that. We're saying, oh yeah, this isn't DV. I'm a victim, and this person is obviously, Ashley Benefield is obviously lying. She's obviously faking. She didn't shed a tear. There was no snot coming out of her nose. Therefore, she must be guilty. She was not in fear for her life. But it seems like this juror, or juror, depending on where you are, was the perpetrator of DV against her husband, according to all of the exhibits that they submitted. Yeah, she was the respondent. So she was the one perpetrating. And also, she filed a protection order against him as well. Well, in 2016, she filed one against another guy, Mr. B. And then something was filed against her in 2003 by her ex-husband, 2003 and 2004. So in 2003 and 2004, she was allegedly the perpetrator. And then in 2016, she filed a petition for a restraining order against Mr. B, some other guy who allegedly grabbed her by her hair, hit her in the face repeatedly, causing a black eye, damaged the inside of her mouth. So not only was she a perpetrator, but she was also a victim, according to these court documents. And that's huge. Laura said no DV perpetrator should be on the jury. Shocked. But that's the thing. That's why they do jury questionnaires, to weed these people out, and then they can be questioned about it, right? So that's a problem. Kimmy, was this done purposely, vindictive? I don't know. I don't know. Why else would somebody lie on their jury questionnaire to get on a jury? That's insane. Thank you, Danielle, for gifting a membership. You are so amazing, so kind, and so generous. And that is crazy. And then there was a guy named Hoodie Guy. What was his name? Hold on. Let's go back to him. That Hoodie Guy, he's not really a YouTuber. He has a YouTube handle. That's about it. He's got a YouTube username and he participates in chat. And he was in the long crime chat saying, my sister's on the jury. Here's what's going on in there. And that's crazy. My sister snuck a flip phone in. Yeah, that's in violation of the sequestration order. They're not supposed to have any devices in there while they're deliberating. So this is a big problem. It needs to be looked into right away. And so hopefully they will. I have another motion here, thanks to Nosy Rosie. Everybody thank Nosy Rosie. They also filed same day, August 9th, a motion to disqualify the judge. Let's see what this is about. I'm reading it here with you for the first time together. It's a real live reaction video because we just took a break for lunch from the Robert Telley's Boss Baby trial in Las Vegas, which will not be starting until 4 p.m. Eastern. So we decided to create this stream and come over here and lay some information on everyone about what's happening in Florida with the Ashley Benefield post-trial motions. This is the second motion. This is Ashley Benefield's motion to disqualify the Honorable Stephen White, supporting affidavits and incorporated memorandum of law. Ashley Benefield by and through undersigned counsel and pursuant to section 38.10 Florida statutes 2023 and rule 2.330 of the Florida Rules of General Practice and Judicial Administration hereby submits her sworn motion for disqualification of the presiding judge. Ms. Benefield fears and believes in good faith based upon objective facts. She will not and cannot receive a fair hearing and or sentencing on account of the personal bias and prejudice of the presiding judge against her and in favor of the state of Florida. First section is called basis. The court's conduct in open court immediately prior to commencement of trial on July 22nd of 2024 and at the July 30th, 2024 verdict improperly prejudiced the defendant. Specifically, the court's declination to voluntarily step aside, as well as the court's arbitrary and capricious refusal to so much as even acknowledge Ms. Benefield's request for post-trial bail, created such apprehension for Ms. Benefield that she reasonably fears she will not receive a fair hearing and or sentencing because of the court's personal bias and prejudice against her. You remember that post-trial, they asked for bail or for her to be remain out on bail, and it was very quick that they came over and cuffed her and took her away and sent her back to jail. No previous disqualification motion has been filed in this case, and a transcript of the post-verdict bond request is attached, Exhibit 1. The actions taken by the court, i.e. its complete refusal to even acknowledge the defendant's motion, yet alone entertain, evaluate, and rule on it, plainly appeared to the defendant that the court never intended to consider it, and remand was the only option, given the court's consistent display of prejudice against Ms. Benefield and in favor of the state throughout the trial. Just take a look at these footnotes. Footnote 1 says, while no prior motion to disqualify has been filed immediately prior to commencement of the trial, undersigned counsel requested the court voluntarily step aside. Make this bigger for myself. Owing to a prior order wherein a public statement was made by the judge that Ms. Benefield was guilty as charged. Quoting from the court's September 18th, 2023 denial of Ms. Benefield's stand your ground order on page 26, paragraph 3, the court stated, quote, considering the totality of the competent and substantial evidence admitted during the stand your ground hearing, the state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. Well, that's a pretty scathing decision, especially since Ashley Benefield did not even testify at that stand your ground hearing, so things have changed since then. It's a pretty good argument. Reality check, thanks for the 5. Eva did a TikTok with a copy of the email, said Ashley tried to hire someone to what? Maybe this is why email supposedly was sent to the judge. Funny, she posted after. I don't know. I don't use TikTok or follow her on TikTok. DK, thank you for the 20. As a true DV survivor, my heart broke for Ashley. This behavior is beyond disgusting. I hope there are charges possible for that juror. Kudos to the brother for being an idiot and sharing the info. Yeah. That hoodie guy may have just blown up the verdict in this trial. Why is it? Why are people so, all right? Well, you know what? It's a good thing. It's a good thing for Ashley. It's a good thing for the defense that he did that. But you're right. Why are people so stupid? They need to be the first person with all the information. And okay, he just outed his sister, and that's a big problem. Ashley's incarcerated. Ashley was cuffed and sent to jail. Do not pass go. They sent her back. Footnote number 2. It said here, given the court's consistent display of prejudice against Ms. Benefield and in favor of the state throughout the trial. And then we go to footnote number 2, which says, it's so tiny. I need to make this bigger. From quashing defense subpoenas for material witnesses to improperly restricting Ms. Benefield's right of cross-examination, refusing to admit corroborating evidence of Ms. Benefield's defense, i.e. her 9/18/2017 letter detailing various acts of DV by Doug Benefield and her characterization of him as possessive, controlling, and manipulating, which has left her, quote, feel fearful for my life and safety as well as that of my unborn child. And quote, I now understand why Eva used to tell me she was afraid of you, end quote. The court has consistently endeavored to water down the impact of any evidence submitted by Ms. Benefield, up to and including refusing to allow Doug Benefield's admissions under oath of various and sundry acts of DV, in particular his explanation casting blame for the acts on Ms. Benefield. Classic abuser mentality, despite their admissibility under Rule 404B1 of the Florida Evidence Code. Additionally, among other things, by refusing to read back the witness's testimony in response to a jury question, and moreover, refusing defendants' request to inform the jury they could request a readback, as well as forcing a verdict by refusing to send them home for the evening despite leaving the jury to deliberate after 9:30 p.m., more than 12 hours following their arrival. The court was on a determined and a successful mission to obtain the result it drove. We talked about that. We talked about the readback and the magic words and how the judge would not allow the readback because they didn't say the magic words, "We want a readback." We talked about it at length about how jurors do not know that they're entitled to it. They don't know that they're supposed to ask for it specifically. And we thought at the time that was a problem. So interesting. Going on with this footnote, the favoritism shown the state by this court was obvious. From suggesting the state file a Daubert motion challenging the defendant's DV expert, which the court allowed in violation of the agreed deadline for motions, to instructing the state during the trial testimony of Manatee County Sheriff's Office Detective Brian Keelis, how to overcome the court's initial sustaining of defendant's objection by establishing the silent witness predicate. See Shore Mariner Condo Association versus Antonius with a citation and another case. Here's the memorandum. It is the established law of this state that every litigant is entitled nothing less than the cold neutrality of an impartial judge, citing two cases. In this instance, Ms. Benefield received anything but that. Canon 3 of the Florida Code of Judicial Conduct declares, a judge shall perform the duties of judicial office impartially and diligently. Under subsection E entitled disqualification, it states that 1, the judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where A, the judge has a personal bias or prejudice concerning a party. And then it says F, so it goes from A to F. The judge, while a judge, has made a public statement that commits or appears to commit the judge with respect to Roman little 2, an issue in the proceeding, or 3, the controversy in the proceeding. Quoting from its earlier decision in Ray Barnes, the Florida Supreme Court stated, quote, in making that determination, the court has often pointed out that the judges should be held to a higher ethical standards than lawyers by virtue of their position in the judiciary and the impact of their conduct on public confidence in an impartial justice system, citing Boyd. Accordingly, no other principle is more essential to the fair administration of justice than the impartiality of the presiding judge. Holding that judge failed to promote public confidence in the integrity and impartiality of the judiciary when he injected himself and his office into a case by advocating for a defendant. Immediately prior to the trial getting underway, i.e. before voir dire and jury selection began, undersigned counsel appealed to the court's sense of integrity and oath of office, wherein the court agreed to uphold the fair trial provisions of the Constitution of the United States, as well as the Constitution of the state of Florida, and beseeched the court to disqualify itself and step aside. Specifically, undersigned counsel raised the issue of the court's conclusion embodied in its order denying Ms. Benefield's stand your ground motion and inquired how the court could possibly sit and decide the issues objectively when it had already publicly concluded Ms. Benefield was guilty, as charged. The request was ignored. Section 38.10 Florida Statutes 2023 and Rule 2.330 of the Florida Rules of General Practice and Judicial Administration govern such motions such as this. See City of Fort Lauderdale v. Palazzo. The rule may be invoked when a party reasonably fears that he or she will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. Subsection 8 limits the judge against whom such a motion is to be filed to determine only the legal sufficiency the motion has, and she shall not pass on the truth of the facts alleged. When a party seeks to disqualify a judge for alleged bias, the facts and reasons for the belief of prejudice must be taken as true, and the judge may only pass on the legal sufficiency of the motion and supporting affidavits, citing Brown v. St. George Island. The standard for legal sufficiency has long been established. The test of sufficiency of the affidavit is whether or not its content shows that the party making it has a well-founded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It is a question of what feeling resides in the affiant's mind and the basis for such feeling. Citing two more cases. The Florida Supreme Court previously explained the analysis required in determining whether such a motion is legally sufficient. A party seeking to disqualify a judge need only show a well-grounded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It's a question of how It is not a question of how the judge feels. It's a question of what feeling resides in the affiant's mind and the basis for such feeling. The question of disqualification focuses on those matters from which a litigant may reasonably question a judge's impartiality, rather than the judge's perception of his ability to act fairly and impartially. Livingston v. State. In Simpson v. State, the Supreme Court found a motion to disqualify legally sufficient based on the judge's statements that suggested the judge had made a credibility determination against a party. Given the court's stand your ground order, Ms. Benefield surely has reasonable grounds to believe the court has prejudged her credibility, and anything she said at trial, or will say at sentencing, will be ignored. But even more immediately, for purposes of post-trial release, the court's indifference and refusal to even entertain her request leaves her with reasonable apprehension that creates in the mind of Ms. Benefield and her attorney that such efforts will never be evaluated objectively. Disqualification is required where the trial court states its belief that a party is guilty prior to trial on the merits. Kind of sounds like he did in that order on the stand your ground motion. We went into the Ashley Benefield trial together as jurors. We did not go over any of the pretrial motions like we did in Karen Reed. So this is interesting. And it differs from Karen Reed in that in Karen Reed, it wasn't the judge who came out publicly and said that Karen Reed was guilty. It was the DA himself, Michael Morrissey. Please hit the like button. Thank you, Debbie Blair. Thank you. Additionally, Ms. Benfield now having testified, little doubt remains that the court has concluded her testimony was untruthful. In Carrington Mortgage v. Nicholas, the 3rd District Court of Appeal noted, the test for determining the legal sufficiency of a motion for disqualification is whether the facts alleged would cause a reasonably prudent person to fear that he or she could not get a fair and impartial trial. We have already held that the judge's commentary concerning the credibility of the petitioner before the completion of the petitioner's direct examination or presentation of any witnesses in support of her case is sufficient to create in a reasonably prudent person a well-founded fear that she would not receive a fair hearing before this judge. Kind of sounds like what's happening here. I mean, the case seems to be on point. See also Owings, Corning, Campbell Soup v. Roberts. As a general proposition, a statement by a trial judge that he or she feels a party has lied in the case is generally regarded as indicating a bias against the party. Statements by a trial judge which suggested that the judge had made a credibility determination sufficient. Given the court's public statement relative to Ms. Benefield's guilt, its history of impeding the defense at every turn, its handling of the questions leading up to the verdict, and refusal to even respond to counsel's post-trial bond request, all created a well-founded fear Ms. Benefield would not receive a fair trial and or sentencing before this court. Ms. Benefield objectively believes the court has now prejudged her entitlement to post-trial release, and her sentencing shall be characterized by an equally biased judicial perspective. Under these circumstances, the court is obligated to grant the disqualification request. Conclusion. It would have been appropriate for the court to have voluntarily stepped aside when counsel requested it, immediately prior to commencement of trial. Now, given what transpired since that request was made, Ms. Benefield involves a formal written request supported by objective facts, as well as independent affidavits and undersigned counsel's certificate of good faith. Here's the certificate of good faith pursuant to Rule 3.220E1 of the Florida Rules of General Practice and Judicial Administration. I certify the instant motion and statements in support are made in good faith. XOXO Neil Taylor. Verification signed by Ashley Benefield, August 7th of 2024. This is interesting stuff, my friends. This is interesting stuff. And I think if it is shown that what they said about the jury potentially being tampered with is true in the first motion that we just went over together, she has to get a new trial. I mean, this is merely right now a motion to interview the jurors, but it says it's in conjunction with her motion for a new trial, which I do not have a copy of right now. So we can't go over that right now. But this is crazy. If this juror or juror number 15 lied on her voir dire questionnaire and had in fact been involved, as alleged, in several DV proceedings, not only as the perpetrator, but as the victim, and lied about that on her questionnaire, that's a huge problem. And then we have another guy, that hoodie guy, posting in Law and Crime chat that his sister was in the jury room, it was on the jury, snuck her phone in and was talking about the split of the jury and that it was the man that was the holdout. It's a big problem. And it could entitle her to a new trial. I don't know if there's been any responses to this yet. It was filed on the 9th. It's only been 6 days. They have usually at least 7 days to respond. I don't know what the Florida rules are, but this could get her a new trial. It should at least get her some interviews with these jurors. Thanks, Reality Check, for clarifying. Eva said Ashley tried to hire someone to take Doug's life. Really? What say you, my friends? What say you? Pamela the Camel, the juror questionnaire didn't matter for the Ghislaine Maxwell case. That was a New York case, right? Federal court, I believe. I'm not familiar enough to speak on that, to opine, but thank you for pointing that out. They'll respond. What happens if they don't respond? They're going to have to put in some responsive papers to this because they're going to want to oppose it. I mean, as of right now, this is going back in front of the trial judge, Judge White. Eva shows the receipts. That was bombshell information. I mean, right now, the argument is not about whether she was guilty or not guilty or whether the jury came to the right decision. The question is, if this juror lied on her questionnaire and they've got the receipts that not only was she a victim of DV, but a perpetrator of DV, and they have at least 3 separate cases, and she lied about that, that's a big problem. And that's enough to set aside a verdict and get a new trial, in my opinion. So, yeah, this was filed a week ago. Thank you, Nosy Rosie. Everyone thank Nosy Rosie for sending this out to me. It's filed on the 9th. Tammy's like, I don't really want to hear what Cruella has to say. And it's not really about what Eva's saying now. This is about, in my opinion, the most important issue right now is this juror and if she lied. But it seems like they've got all the receipts on it. Andy Shell's Kitchen, thank you for the 5. And watching prosecution on post-interview, I feel that they're exceptionally clueless about DV. It's infuriating. You're not alone in that. A lot of people felt that way. Auntie Shell, and there's a lot of survivors in this chat and a lot of people in this chat who very sadly and unfortunately know way too much. And I think that it is so hard for anyone to judge how anyone else would behave on the stand, would behave when they're recounting situations. A lot of people tend to disassociate from their bodies. There are some, well, first of all, we had Jules was in the courtroom and she said there were actual tears. People were saying there wasn't actual tears. But also there are certain antidepressants that will prevent tears. People can tell you that. People in the chat have told us that, and we know that. But I think every single survivor or victim behaves differently. And I don't think that there's any one way that someone should respond when they're retelling a story of what happened to them. Karaoke, thank you for coming in from Canada, says makes me suspicious of everyone on the prosecution. Yeah. We'll see what happens with this. We'll keep following it. Thank you, Nosy Rosie, for sending it to me. Going to go back to court in Las Vegas in a few minutes, but here's Nosy Rosie coming in. Nosy Rosie said, I had a horrible reaction to the prosecutors. I get angry tears when I see them. I think you're not alone. Iceman says, plus uncontrolled shaking cannot be faked. I know. That's what I had, a visceral reaction to her testimony. I just did. That's just, my opinion. And look, whether or not she was in fear for her life at the time leading up to and right before the shooting is a subjective question of fact for a jury. And in this case, the jury found her guilty of manslaughter, and she's facing up to 30 years in prison. The sentencing has been set for, I have the date, hold on. I believe it's October. And so part of this motion is to get the judge off this case for sentencing because they don't think that he can be impartial, that he's got a bias based on his decision in the stand your ground motion. And I think it's a good argument. Her sentencing is currently set for 8:30 a.m. on October 22nd. Danielle says, I totally tended to go into shutdown mode, no feelings whatsoever. Look at Patronus. Hi, Patronus. I'm sorry about this. There's so many flip-flops emotionally and within the body. I cried every day for a year after getting away. I'm so glad that you did. Then went a year with no tears and incredibly numb, but very broken. I'm so sorry. And again, everyone reacts differently, right? I don't think that we can judge how a person should react. Goose Chow says the judge sure sounds like was bias AF in that stand your ground hearing. Well, it's actually in the written decision that they're saying showed bias. And if what they're saying is true, Joanne Byer, thanks for being a member for 8 months, says mistrial at least. The juror who lied on the questionnaire, breaking rules such as bringing a phone and sharing privileged information, in my opinion. Yep. And it's two different jurors now. We got juror 15 who lied on a questionnaire. And then we have a different juror, allegedly the sister of that hoodie guy who was in the law and crime chat. And we don't know if that's true. And we won't know if that's true until if and when the court orders a hearing to bring the jurors back in. Sam says, for me, I come from California. I don't think the distress she was portraying wasn't real. She didn't seem fearful at all when talking about the fighting. Margaret, 1988, says, I could not even cry. There were no tears left anymore. Marissa says, Lori Vallow was treated better in her trial than Ashley Benefield. Z said she called him over, ran into a room with only one way out in a house she was living over 2 years. He was picking up the last box and turned away. I don't know. I think the evidence could be interpreted lots of different ways. The jury was the finders of fact in this case. I think the fact that one of the jurors may have been a perpetrator of DV is a problem. But also, I would say to that, I don't think that time takes away the ability of someone to assault another in an intimate situation. Why do you think it is that victims are notified when their perpetrator is released from prison, 10 years after the fact? There's a reason for that, right? Because they could still come back and commit an act. I don't know that, the argument that, 3 years had passed and he didn't do anything to her in the meantime. Well, except for stalk her from South Carolina, North Carolina, to Florida and try to buy or move into the house right behind where she was living. I don't know. So I don't really, personally, I don't buy the time argument that just because 3 years had passed, because there were things that happened. Yeah, and like the defense is pointing out, there were things that were not allowed in, like Doug's admissions of the violent things that he did, and that letter that Ashley wrote to Doug, explaining to him why she was leaving. Is it enough to get a new trial? Combined with the juror stuff, I think they should absolutely hold a hearing with the jury. We're seeing that a lot lately. We're seeing it in the Karen Reed case. We don't know what the judge is going to do on that case. And we don't know. Well, we do know in Murdoch, the South Carolina Supreme Court has decided to hear the jury tampering issue. So there was just an issue, decision that came out yesterday, the day before. The South Carolina Supreme Court has decided to hear that issue about Becky Hill tampering with the jury. They leapfrogged right over the appellate court to the Supreme Court of South Carolina. And there's a very good chance, and I said this from the beginning too, that I thought that Murdoch may get a new trial based on what Becky Hill did and her interactions with the jury and writing a book and all that stuff. It's crazy. Yeah, Leslie says she tried to go out the front door and he didn't let her and he hit her. Told her she was effing done. So there's that. Andrea says no matter how long, that fear is always present when an abuser is on good behavior, right? There's ups and downs, and you guys have talked about it, highs and lows, and you always want the good times to come back, and that's why people stay. And I think it's a complicated situation. I think we heard testimony that the authorities in Florida, especially that one detective, he would not listen to her. He thought she was a pain in the ass for even asking him to do something to enforce the order of protection that she had that was valid in North Carolina. So I think she tried. But the question now is whether what happened and what they're pointing out happened with regard to the jury and the two jurors out of 6, by the way, which is 33 and a third % of the jury here, warrants interviews of the jury. And if so, in my opinion, if that stuff is true, if it can be proven to be true, I think it merits a new trial in Florida. And so there's that. Pilgrim Shadow says it's shocking how women judge other women. Yeah, and you know what? It's so interesting because we talked about at length, and I brought it up several times. I said, what do you guys think? There's 5 women on the jury, and Jules, who was our court watcher and was in court, said, the women were in their 60s, 70s, and 80s. We had a lot of discussion about what we thought, if that would be good for the defense or good for the prosecution. Older women, they've been through it all. But if it turns out that one of those women was a victim and a perpetrator and lied on her questionnaire, to me, that's huge. To me, that's huge. And that should cause a mistrial. That should entitle her to a new trial. In which case, if it goes to a new judge, she could be let back out on bail pending the new trial. So there's a lot of interesting twists and turns here with regard to Ashley Benefield. And we're going to see what happens. Colors fight that I knew the man would be a holdout. That's interesting. That's interesting. And it was interesting, too, that they were deliberating until 10:30 p.m. When have you ever seen that before? Have you ever seen that before in a trial where they were allowed? Prayers up from Inexplicable Susan. Oh, thanks, Emer42, my new favorite. Hope I get gifted membership. Well, you know what? You've got a chance because after this, we are teleporting back to Vegas, babies. We're going back to Vegas for the Robert Telley's trial part 2. We've already heard from 8 witnesses out of the 20 that the prosecution intends to call. And it's a crazy trial out of Vegas. We're calling it the Boss Baby trial because the guy who's on trial, Rob Tellez, his employees nicknamed him Boss Baby because he looks kind of like the cartoon character Boss Baby. And it's been great so far. It's a refreshing palate cleanser of a trial. So come join us for that. Courthouse Becky's supposed to be back in court October and November. Yeah, she's got some criminal charges pending, and that is going to be crazy. Joanna Petrova, what about a new judge, right? That's the second motion that we read, was the motion to recuse this judge and get a new judge assigned. In addition to, as part of the motion to dismiss, was a motion to recuse. Rassler's mom says women are the worst when it comes to judging other women. We see that. We see that in the comments. If you've ever tried to survive the chat over at Law and Crime, you know that too. And if you're in the cesspool of Twitter, which you know that I am not, you see it every day. You see people who are talking heads on mainstream media news channels blasting women, defendants like Karen Reed for what she's wearing to court, like Ashley Benefield, even like they were blasting like Gabby Petito. Like it's horrific what goes on over there. Hate sells. Hate sells, especially in a cesspool like Twitter, because on Twitter, you're paid for engagement. It doesn't matter if it's good or bad. So if you say something that's totally controversial and everyone comes on and says how much they hate you, that person tweeting still gets paid apparently. Not really sure what their business model is because I left there a long time ago because I don't need that kind of hate in my life. It's people just fighting all day long. Who's got time for that? Who has got time for that? We did karaoke. I did thank you for this, right? Yeah, I did. Joanne Byers says, mistrial, at least jurors who lied on questionnaire, breaking rules such as bringing a phone, sharing privileged information, in my opinion. Thanks for being a member for 8 months, Joanne Byers. You're like one of the OGs. Oh, Rassler's mom, I appreciate you too. I love you so much as well. I love all of you, each and every one of you. Thank you for the 5. Richard Johnson, what's the probability of having her conviction set aside for a new trial? I think that if they do interview the jurors, because listen, it's a 6-person jury, right? So if there was misconduct on behalf of one of the jurors by sneaking a phone in there and texting her brother who was posting on the Law and Crime chat about what was happening in the jury room, that's a problem. And number 2, the second juror who may or may not have lied on her voir dire questionnaire about being the victim and perpetrator of at least 3 different DV cases that the defense has receipts on and case numbers and pleadings. That's 1/3 of the jury. And that, in my opinion, is enough to get a new trial and perhaps get her let out on bail pending a new trial, because that's astonishing. You know, it really is. And not, right now talking about whether Ashley was convicted wrongly or not. But if 1/3 of the jury was tampered with and compromised, it's a big problem. Danielle, but is the current judge going to rule on the pending? Yes, but then it will be appealed unless it's assigned to another judge. Jackie says, is this kind of situation common with juries? We're seeing it a lot more now, but look, before social media, it wasn't really a thing, right? Because people couldn't tweet from inside the jury room or be texting their brother. And the information wasn't as readily available. So, with the advent of the internet and social media, we're seeing it a lot more often. We saw it in the Maya Kowalski case, where they called in juror number 1 and tried to make him look like he was communicating with his wife and that his wife was in YouTube chats, giving super chats. And that was a reason to disqualify the $270 million verdict or whatever it was against the Johns Hopkins All Children's Hospital. But that was, that was a civil case. We're talking about a criminal case here. We're talking about a woman who is now facing up to 30 years in prison based on what could have been a tainted jury. 1/3 of the jury could have been tainted. For sure, says the DNA on her arms and shoulders wasn't allowed in, right? Jules like, wasn't me. I was homesick. I remember, Jules. I remember you weren't there that day. I remember. Darbykin says the question is, did Law and Crime report the hoodie guy or did they sweep it under the rug? I don't know. People could have screenshot it and sent it to the defense. That happens a lot in a lot of cases. The defendants and the defense teams are getting a lot of help from armchair sleuths, detectives, and attorneys. Laura Riker says, I hope the court and Law and Crime report on this and have to eat their words. You mean Court TV. Tammy says, I'm so sick and tired of hearing about jurors that are not honest. And Fire says, especially if hoodie guy was texting her back. Yep. Right, Jules, there was only one man on the jury. And according to these papers that we just read, these motion papers, according to what hoodie guy's sister was telling him, he was the holdout. He was the holdout for not guilty or a lesser charge. So that's interesting. But they got their pizza. Hi, Nina. You're behind, but this is wild. This is wild. We're going to be following it closely. As you know, Melissa says prior research also indicates that the first time a perpetrator of coercive control uses physical violence is more likely to end in fatality. Ashley stated he was physical for the first time. That's right. Laura says she's facing 30 years, and in Florida, you serve a mandatory 80% of the sentence. Don Canine, that's right. Karen gets lambasted because of her skirt or her smile, one or the other. They don't like her smirk. They don't like her outfits. They're not appropriate for court. But Officer John O'Keefe was not hit by a car. So I really don't care what she's wearing. That's enough for that. Siege in Texas says at least misconduct enough for a new trial worthy of reinstating her bond. That's what I was thinking too. That's what I'm thinking. Kiwi Rob, what's the worst that could happen for the state if this is confirmed? Well, the state wasn't, there's no allegations that the prosecutors were in on any of this. So let's not, so I don't think that's what you mean, but the worst thing that could happen is that Ashley Benefield, they call the jurors in, the jurors confirm what is set forth in that motion. That's 1/3 of the jury. That's a problem. They set it for a new trial. They overturn the verdict and they could let Ashley back out on bond. So, I mean, if that's a bad thing for the state, I guess that's the worst thing. Nosy Rosie says, so if another judge comes in, would he sentence her? How is that fair? It's crazy. They could have a new judge come in and decide this motion about the juror issue. There's a lot of different combinations of things that could happen. So we don't know. We'll take a step back and see. I'd like to see the opposition papers, Nosy Rosie. So I know you're on it. Send me whatever else you want to send me and we'll talk about it again. So everyone says, be safe. Please take safe actions and have safety in place. Family, support team, police. I'm going to put the number here for the National DV hotline. It's 1-800-799-SAFE, 1-800-799-SAFE, or 7233. Rachel says jurors are being exposed. This probably happens all the time. Jurors need to do better. This is so true. So true. All right, my friends, I am going to hit end on this stream. I'm going to teleport you over to the afternoon stream on the Rob Telley's trial out of Nevada. So we're going back there. You guys who are with us right now, come on over. It's a fun trial. We're having a great time in Vegas. We're going back to Vegas, babies. Thank you, mods, again. And also, please hit the like button on your way out and then on the way back in. There's at least 2,322 of you here right now. It would really help the channel, helps the algorithm. We're staying on top of the Ashley Benefield post-trial motions. Now we're going back to Vegas to see the Boss Baby trial. So remember, as I always say, be cool, be kind, be classy. It is not hard. It is so not hard. Safe travels, my friends. Let me know when you teleport over to the other side. I'll see you soon. Peace. Trial's going to be starting in like 5 minutes. I'll be there in 2.